Before we start the Q&A on the keynote, some of you arrived during the keynote, but really all three panels are looking at the same issue from a different perspective. So we're basically asking, what are the limits that trade and investment agreements impose on states? Is it a good thing or a bad thing? And if it's a bad thing, even in part, what do we do about it? Right? Those are kind of the questions we'll be looking at. I attended a closed session in Geneva not long ago about the difference between trade and investment agreements, which is something else we can talk about. And somebody thought that he made a killer argument, but I'll just put it out there for those of you who said, not every country is stupid. There must be a good reason they signed these deals. So we can talk about that too. But with that as our backdrop, let's just open it up for your questions. I know I have a few, but I will not ask the first one on the keynote, and then Professor Ghosh will present, and then we will continue the panel discussion with that additional presentation. I think the editor-in-chief in person will give you the microphone if you have a question. So please raise your hand, and Tom Johnson will be happy to provide a mic. Anyone? Yes, Sean in the back. And please state your name, because the people on the camera cannot see you. They can hear you, but cannot see you.
So thank you both for your intervention and your work in this area for a long time. Preface by just saying,
Do you want to give us name and affiliation, please?
Oh, Sean Flynn,
yes, thank you.
American University,
thank you.
Washington College of Law. So I'll preface by saying I kind of want to hear, there's a whole lot of other people in the room that are addressing this issue, so I'm a little hesitant to kind of like start the whole debate when there's a bunch of unknown positions out here, so I'm really interested to hear what Shuba and Jason and Cynthia are all going to say. And I don't know how that'll structure this overall discussion. But let me just kind of take you up on the piece that you left out, Susie, and maybe Daniel wants to talk about it. But how does human rights influence all of this? So there's these interpretations out there. The panel seemed to have interpreted that clause in NAFTA gave it the jurisdiction to decide what the intellectual property chapter requires, for instance. That's a step that my own position would not go down. I don't think that's a necessary interpretive move, and human rights might help you interpret that, or notions of sovereignty. So when the TPP or the NAFTA says consistent with the IP chapter, the question is who gets to determine that? Who has jurisdiction? Do you have to wait for state-to-state adjudication? Do you have to wait for a TRIPS judgment to decide what TRIPS means? But it could be that, or it could be any of the other questions. How do you see human rights kind of intervening in this? How do human rights norms help us interpret ISDS norms?
I actually have a slide. Yeah, I actually have a slide, but if you look back at the Uruguay case, for example, remember I said that in its police powers, states can regulate. And then they ask, well, what are police powers? And they use VCLT 31 to say, look at international law. And one of the international laws that they look at is human rights law. So they look at the European Charter on Human Rights, and they come up with the notion that health matters. And if you look at the European Charter, you'll see that there are a lot of other things too. So education, why not look at the Universal Declaration of Human Rights, right to the benefits from from what creative people have done, cultural rights. So you could get it in that way through the police powers argument. And then, I think Susie would also say when you look at IP as a whole, so yeah.
So that's right, and that's one of what we think is the good, one of the good features. But of course, that is using the police powers to regulate. So then jurisdiction is decided. And so the point that Rochelle made, that in that case, there isn't state investment, so there's no analysis of the particular feature of human rights as it relates directly to the IP. So it's as it relates to the regulation. So my comment about 31(3)(c not being fully used kind of drives at the threshold jurisdictional point of when you define an investment, right? And one of the reasons to look at the international relations between the parties there is then you bring on board the other aspects of IP. Now, in all honesty, it's pretty hard to engage with the human rights discussion at that jurisdictional point. But it's also possibly, some may think, I'm not sure that I think this, the very point at which you need to, because otherwise you're having this human rights debate after a country is having to finance itself and so on and so forth. So, you know, in a sense, by looking at it at the jurisdiction end, you've got a similar problem that, Sean, you've written about too, is how do you engage that when analysing what an IP right is? And some tribunals will do that in other ways. I mean, in non-IP cases, there are discussions about the broader role of public international law and investment, and that's a very contentious area, right? And there's currently a couple of decisions that talk about that, and they disagree with each other. So the scope there is huge, but I think the point of the human rights analysis, it's great to engage with other regimes, the European Convention about human rights, but you're already well in it, right? And so that difficulty remains. And of course, the Born dissent more or less says, this convention isn't relevant, right? So other litigants will take that up.
I mean, the other thing you might say is, what are the legitimate expectation of parties who hold IP rights? And Lily's claim was they had this, you know, this 20-year right, and there was no contingencies. The fact of the matter is there are contingencies. In the Lilly case, the contingency is that the patent's going to be invalidated, but other contingencies include some level of regulation to protect the health of the citizens of Canada. So you could bring it in that way as well.
Oh, there's several hands in the back. Let's see.
Hi, Cynthia Ho from Loyola Chicago. So I really enjoyed the discussion that you guys presented, and I'm very sympathetic to the argument that IP and ISDS should require the company to actually make some kind of investment. But it seems like there are a lot of prior tribunals and also academics who have suggested, well, that's not necessarily how it should be. I think it's called the Shalini Test. Not everyone buys into you need to make the investment. So I'm wondering how you deal with the fact that there is resistance. Like, do you think that tribunals could be persuaded that IP is so different that you should consistently always apply this investment test? Or is it more, this is what you suggest, but maybe you're less skeptical it'll work out in practice?
So if I begin, so in the jurisdiction decision in the Philip Morris case, there is a discussion of the Shalini test, and that's where the finding comes out that this is not a mandatory list of characteristics. It is characteristics which will sometimes be there and sometimes not. And of course, they're referring specifically to contributing to the economic development, because Uruguay, in fact, argued that this investment actually was regressive for Uruguay, that there could never be any valuable development. And so I think that one could actually spend a lifetime reading conflicting views on Shalini, as you do. But the point there is it is a list of characteristics, right? And the Firestone, Bridgestone and Firestone case, which doesn't involve public health, cultural diversity, so it doesn't engage the human rights side of the equation. Interestingly, after looking at Shalini, that is precisely why they say the mere registration actually doesn't confer any economic benefit. So in the sense, a case that is purely commercial has actually been able to recognise this feature. So I wouldn't revert to saying, no, we have to have all the Shalini characteristics, because clearly, as you indicate, there's a lot of opposition to that. But I think that what one could argue is that some characteristics are going to be more prevalent in some types of investment, and one might say that actual investment accords with the policy of IP, because, Cynthia, you're the last person I have to say, but of course, you know, even though we know there's no way to force countries under TRIPS to actually invest in foreign places, that is at least one of its rationales expressed in parts of the agreement and so on. So actually requiring that to be a characteristic of investment is consistent with the underlying notion of IP. And if you don't invest, okay, no investment disputes, but you're utilising your comparative advantage. So we think that you can take the economic justifications further to support those principles.
Yeah, I just add, the intangibility of IP is a problem in a lot of areas. Right? It's been a problem in how do you determine personal jurisdiction. It's been a problem in questions about taxation. And looking at these investment cases, there's really not been significant grappling with the fact that IP is an intangible and localizing it has a problem. In many other, choice of law, I mean, you can think of many different areas where courts have seen that this is a problem and have tried to develop a test for deciding when something is actually IP within the state, giving them jurisdiction over it, giving them jurisdiction over the people who are utilizing it or arguing about it. And the issues I find most fascinating is this current question about global erosion of the tax base. So a lot of countries are allowing people to claim that IP is within their state and then having the taxation of that IP be in that particular state. And they're creating these patent boxes. Everybody is having sort of competition over who can tax IP the least. And the OECD has now recognized that the tax base is really going down as knowledge becomes one of the most important assets that people have and one of the most valuable assets that people have. Having these rules that you can make believe that you've created the IP in the state, even though you've done absolutely nothing but do a paper transfer, is not working. So the OECD is actually trying to develop a set of rules about when IP is actually in the state and therefore can be taxed in the state. And we think maybe some of those rules, which are not actually all that different from the conflicts rules, the jurisdiction rules, would also be helpful in this context.
Molly, and then you.
Hi, thank you. Molly Land from the University of Connecticut. So I really enjoyed the talk. I guess I wanted to ask about the Uruguay case and the relevance of human rights arguments. I was really struck by your comment, Rochelle, that, I think it makes sense to look at the asset as a whole and to look at whether it's diminished. And then you said, because people are still smoking, so therefore there wasn't an expropriation. It almost struck me that there's sort of this embedded tension in that the regulation is then only permissible when it's ineffective, right? Because indeed, the regulation is designed to get people to stop smoking. So I'm just wondering, if you see human rights arguments coming in, is there sort of like a built-in limitation in how far those arguments can go? Because at some point you are talking about, what might in other contexts look like an expropriation, or perhaps we need some kind of an exception for human rights arguments to say that, in fact, you are taking their property, but it's justified.
That's why I'm attracted to the public policy argument, because what they said in Uruguay is, on the one hand, we don't think it's much of an expropriation, and then the next paragraph says, but we actually have another way to get to a decision in favor of Uruguay, and that's to say the police powers actually trump expropriation, and that would mean that even if everybody actually did stop smoking because they saw those horrible pictures, it still wouldn't be an expropriation. I don't know what happens with fair and equitable treatment in that case, but it wouldn't be an expropriation. So that's why, you really have to expand police powers a lot broader than we've ever thought about police powers, but it's a very attractive option for that reason.
And if you hang it on a legitimate policy objective, it's not clear at which time you measure legitimacy, right? Because there is a tendency, as you say, to say it was legitimate because it works, but maybe it was legitimate and doesn't work. So that phrase itself is the stepping stone, but it doesn't make any sense, right? It sounds.
If you have to go with Gary Bourne's test and, actually show stuff, there's a chicken and egg problem, or it's catch-22. You can't prove it until you do it, but you can't do it until you prove it.
So if you have a negative film review on public television in a country of a foreign movie, that also would be an ISDS case. No, I'm kidding.
Definitely not fair and equitable treatment.
I'm Jason Yaki from the University of Wisconsin. I really enjoyed the presentation. I feel as if Rochelle has preempted a lot of my comments for later on this afternoon. I think we are on the same. I think we have the same views of Gary Bourne, and especially his dissent in the Uruguay case. I guess I just wanted to briefly mention, I think, one complication with the debate over defining investments and the Shalini case, and that's that in the international investment law world, you have that debate has really arisen, at least as I followed it, out of the fact that you have a dual jurisdictional requirement as to investments, and so you have the investment treaties, which obviously confer jurisdiction upon tribunals, giving the investor the right to sue. But if you go to ICSID, you have what many consider to be an autonomous definition of investment in the ICSID Convention itself. And so the ICSID Convention famously doesn't actually define investment, right? And so that's led to this debate. It's opened up, I think, room to argue that investment should be defined in a way that is more restrictive, taking into account the economic development potential of the investment as a jurisdictional condition for ICSID. As I see it, though, the big problem, and I think you guys recognize this, is that most modern investment treaties contain these very open-ended lists that expressly include intellectual property, often broadly defined, all types, as being an investment. And so I think that the reforms, to me, I think the reforms have to be centered on, primarily on, I think, changing the definition of investment in investment treaties. And then, of course, you have the problem that you have 3,000 plus all of the FTA chapters, and they're all intermingled. And that kind of thing. And so to me, it's really focusing on the investment treaties definitions. It just as an historical fact, I mean, I think we're fighting a lot of history here. I opened up the first allegedly first investment treaty, Germany-Pakistan, and I was surprised, actually. IP is in that definition of investment way back in 1959, at least patents and technical knowledge, which is kind of fascinating to me, right? This has been there from the beginning, and so I think it's... Oh, is that right? Yeah. No, so to me, it's fascinating. So I just wanted to point out, I think, that distinction or that complication, ICSID's definition plus the bits, and get your thoughts on how that impacts your analysis.
Just briefly, because I know we're pressed for time, that's exactly the point where they say, well, there are these two competing definitions. 31(3)(c) requires us to look at the bit as well as ICSID. So it makes no sense to use the international relations between the party for the word investment and the bit, but not for the word trademark, patent, and so on. So that's where I'm driving it. Well, you can't be selective around the international relations between the parties. But I would also say, that's right. And the commentary that says it's really useful to have no definition of investment because many investments take new and unusual forms and we want to be able to capture them all. Yeah. And so I totally agree with you, that relationship is there. But part of the problem I have that with this discussion is it's not just about those two. It's not just about the word investment. It's about the details of the definition and the international relations that exist between the party around those details.
I mean, also, you can...
Sorry. Oh, Rob, I didn't see your hand. Go ahead. Yeah. Can you wait for the mic, just please?
So just to add to the litany of grievances about Gary Bourne's dissent, Bourne also seemed to suggest that it was a denial of justice, that due to some specific characteristics of the court system in Uruguay, there was no judicial procedure to resolve somewhat inconsistent rulings of the Supreme Court and another administrative court, which suggests really an incredible level, of intrusion and attack on a country's domestic court system. It would be like saying in the United States that there's a denial of justice because the Supreme Court does not take cert to resolve a split between federal circuits. So, I mean, if Gary Bourne were right, then, you know, every time, you know, an investor was harmed by the Supreme Court not resolving a split between federal circuit courts, they could make a claim in ISDS. So let's hope that you know, those who are contemplating the future of ISDS are aware that this kind of ruling is indeed possible. And I would also say that Bourne is not, you know, some kind of outlier. I mean, he's a consummate insider arbitrator in the ICSID establishment. So there's no guarantee that you wouldn't get it, and I think this is part of what Rochelle and Susie are saying, there's no guarantee you wouldn't get another tribunal where there would be two Gary Bournes, right? And that's the way the system works. And, you know, and you guys have said so much. In fact, I've been rewriting my remarks for this afternoon because in many ways I was planning to comment on the same cases.
They're the cases that are out there. Yeah, I mean, one of the attractions of saying that perhaps people who are making investments around the lack of IP ought to be able to bring an ICSID case as well is you could say the same thing about the Federal Circuit. The Federal Circuit's a pretty quirky court. It decides overwhelmingly for patent holders, and anytime it's reviewed by the Supreme Court, it almost always gets reversed. And so, you know, having the special court that the patent holders can go to, that's pretty quirky too. But it's not something that could come up in ISDS because, of course, it's helping the right holders and it's hurting user groups. So.
Yeah,
It might be just worth briefly mentioning that Gary Bourne is involved in both the Eli Lilly decision and the Uruguay decision. So for students who haven't read all of them, that's also, yeah.
Yeah, I have the distinct pleasure as an expert witness for Canada to be questioned by Mr. Bourne for about 40 minutes, so it's a lot of fun.
I clerked with him for 2 years.
So before we turn to Shu, I really think I need to ask you the question that I alluded to at the end of the keynote. Sorry. So it was the last point that Susie was making, which is we tend to align the word investment with a right. So there's a parallel between the right and the investment. You have a patent, you have a trademark, which supports, at least in theory, an investment subject to the test that Cynthia was discussing. So you suggest that a company investing in the limit of IP, so not the upper limit, but the lower limit, would also potentially trigger. So and you refrain from giving examples. Well, I will give two that are well known to everyone in this room. Google relies on fair use for its books scanning investment. YouTube relies on safe harbor. Otherwise, there would be no YouTube. So these are major investment by a major corporation. What if the law is changed? What if the safe harbor is removed? What if fair use is reinterpreted by the Supreme Court in the future case and reverses Judge LaValle and says, no, this is not fair use? Is that an ISDS? Now, of course, you'll say, well, it's an American company, it's an American court. Yes, but just have a little bit of a hypothetical fun with me and imagine Google being Google, the very famous French company, right? So, all right. Could they sue? What do you think? You want to go there or?
Yes.
Okay, go for it.
I'm sorry, can I add
I
another
think that that's
example, Danny?
exactly what they will try and do in
Well, you have the
non-American
floor next,
countries, right? So it has been known in trade negotiations, so I referred to certain large internet platforms and you named them. Okay, so it is well known in trade negotiations that other IP types of owners show up and say you can have only this safe harbor and not that one. And that is why in the TPP there is the infamous Google clause, so it was called, although whether it really came from there, about looking at the balance of rights and exceptions in copyright. And it's an aspirational clause rather than a specific obligation. But in fact, to say that there has been an expropriation by the expansion of IP exceptions is precisely what will happen, and it may happen outside of the US first. That is why there is this heavy debate, and of course, Sean and his team are leading some of this. globalize fair use is the mantra of this side of the equation. And the other side of the equation is no fair use because it's too open and it leaves the possibility of expanding exceptions, and you are taking our investment. So I can list you any number of submissions that say you are taking our investment, so they can completely engage with that word. So in countries that don't have that expansive approach, and you know many of them, Daniel, to exceptions, that is exactly the kind of case on the horizon, and a couple of them are beginning, right?
You can also point to some U.S. areas where we do provide for the reliance interests of people who are using.
Yes.
So look at the Copyright Restoration Act. The U.S., when it went into the Berne Convention, had to restore copyrights for works that had fallen into the public domain in the U.S., but not in the country of origin. And when the U.S. finally actually implemented that, which took 10 more years after it joined Berne, and only did it at the time of the TRIPS agreement, they actually provided for these reliance parties. Did they provide enough for reliance parties? So if a copyright was restored and you were actually relying on the fact that the stuff was in the public domain, you got a year to sell off inventory, and you continue to use derivative works, but only if you were paying royalties. I don't know that it was enough, but it does show you that we actually do think about people who make investments around the public domainness of something actually have an interest that deserves to be considered.
And another example in the paper is where countries actually rely on exhaustion of rights and will start to parallel import, even though the rights haven't expired in other countries. Well, if you reverse that regime and you say no one should parallel import or exhaust rights, which is kind of, as you know, a trade position of some, in fact it was the US position originally in the TPP, then what about those reliance interests, those industries that have created the product for countries where it's not still protected? And the list can go on.
Fashion in this country, I mean, there's, yeah. I think this is...
Apotex. I mean,
Apotex,
had a reliance interest in the Promise Utility Doctrine, and poof, Canada changed that.
What
After
a-
NAFTA, out of the blue.
Shuba, what a great segue. I think it's yours now. Do you want to move to your presentation, or?
This takes away from my time or not, but I did want to add another example. I was trying to work through my head how this plays out, and I think it can play out and that's Eldred. So to play out Daniel and his European equivalent to Google, Eldred in Spain. So,
Eldredo.
copyright term extension, right, where there was no consideration that Eldred was about to launch this public domain access. There was not even in the Economist's brief was there a discussion of that.
Well,
Right, so-
in the opinion, they say, oh, you don't have an interest in the
Right,
public domain.
there's no
but-
reliance, not even a
yeah,
reliance
yeah,
interest,
but-
right.
It's even now
just
being
seems
said
so
to New
wrong.
Zealand
Oh, no.
that because we still have 50 years, that we are actually expropriating by not extending our term. We are being told that, right?
Yeah, yeah.
And,
But I'm not sure if that, I guess I have to think through how this plays the other way, because if Eldred is
Yeah.
about deference to the nation state, then if the nation state expands limitations and exceptions, then why shouldn't that deference continue? I mean,
Well, under Gary Bourne's theory, you'd
Yeah,
actually have
right.
to show that there was a relationship between the extension and incentives to
Right,
invent.
right,
Now, people
right.
have been trying to show a relationship between IP and incentives to invent since day one.
Right,
They've
right.
never managed to show it.
that's because they're
And-
probably more
right.
incentives from not having.